We'll begin today's deliberations. On the first day, a book was released on the statehood of Palestine under international law. Today there'll be further deliberations on this subject. I'll request the Secretary General to introduce the subject.
Thank you, Madam President, Excellencies, distinguished delegates, ladies and gentlemen. I have the honor to introduce the topic, deportation of Palestinians and other Israeli practices, among them the massive immigration and settlement of Jews in all occupied territories in violation of international law, particularly the Fourth Geneva Convention of 1949. This issue was included in the agenda of the organization in the year 1988 upon the initiative of the Islamic Republic of Iran. Since that year, the Secretariat has closely monitored the developments regarding this matter. At the 51st annual session of ALCO held in Abuja last year, the Secretariat was mandated to conduct a study to examine and establish the legal requirements and principles that would determine the status of Palestine as a state, taking into consideration the requirements of international law and existing international norms and standards, particularly the provisions of the Montevideo Conventions on the rights and duties of states. Following this mandate, the Secretariat has prepared a study on the statehood of Palestine under international law. This was launched, as mentioned by the Honorable Madam President, the first day of our annual session. The study has paid attention to the international law on recognition of states, the criteria on which statehood is determined, and the extent to which Palestine satisfies these conditions. Attention is also bestowed on the Palestinian people's right to self-determination and its impact on the claim for statehood. In addition to this, the study also makes a survey of the history of the conflict and the Israeli practices in the occupied Palestinian territories and documents the work done by ALCO on this topic so far. The study also focuses on the jurisdiction of the ICC with respect to the illegal acts committed by Israel. Excellencies, ladies and gentlemen, the illegal military occupation of Palestinian territories and the human rights abuses perpetrated on the people of Palestine has now been continuing for more than 4 decades. Despite international consensus expressed through the binding resolutions on the Security Council and the General Assembly of the United Nations, the occupying power continues to defy international law and the will of the international community. Even as peace talks have now resumed after a significant gap of time, the occupying power is continuing with its expansionist policies. Time and again, the international community has asserted the application of the Fourth Geneva Convention relative to the protection of civilian persons in time of war to this conflict. The illegal annexation of Palestinian land, the creation of Jewish colonial settlement, and the massive deportation of Palestinians are all actions in violation of humanitarian law and international law. The denial of water and other essential services to Palestinians and the continuing blockades of Gaza that prevents the Palestinians from exercising their right to seek refuge in other territories are acts in the nature of collective punishment imposed on the people of Palestine in violation of the Geneva Conventions. Excellencies, ladies and gentlemen, we must also recall the historic judgment of the International Court of Justice that has reaffirmed the illegal nature of these practices, in particular the construction and maintenance of the wall, that separate and isolate a group of Palestinians. The report of the Special Committee to investigate Israeli practices affecting the human rights of the Palestinian people and other Arab territories has well documented the human rights abuses perpetrated by Israel. The salient features of the report are highlighted in the special study prepared by the Secretariat. These actions and the continuing expansionist policies of Israel strike at the root of all hopes for peace. Excellencies, ladies and gentlemen, the situation in Palestine is grave, and the principal tool to redress this is ensuring compliance with international law. ALCO has time and again asserted the illegal nature of Israeli practices in the OPT and called for the resolution of the conflicts in accordance with the principle of international law, including the provisions and principle of the Charter of the United Nations, Universal Declaration of Human Rights, the regulations annexed to the Hague Convention of 1907, and the Geneva Conventions, in particular the Fourth Geneva Convention, regarding the protection of civilian persons in time of war. It is also relevant here to recall the widely supported United Nations Security Council and the UN General Assembly Resolution 242, 338, and N1515, which affirm the legal obligations of Israel to withdraw from Palestinian territories obtained in the year 1967. It is in this context that the declaration that was made by the State of Palestine under Article 12, Clause 3 of the Rome Statute was of significance. Let me recollect here that the Rome Statute of ICC was negotiated and concluded to put an end to the culture of impunity from punishment for violation of the laws of war. However, after nearly 3 years of deliberations, the Office of the Prosecutor refused to act on the application, concluding that it was unable to decide whether Palestine possessed the necessary qualification to be considered a state within the meaning of the Rome Statute, and hence accept the jurisdiction of the court. The special study conducted by the Secretariat notes that Montevideo Conventions on the Rights and Duties of State embodies the 4 basic criteria employed in international law to determine statehood. That is, first, a defined territory; second, a permanent population; third, government; and fourth, capacity to enter into relation with other states. The study notes that there are convincing reasons to conclude that Palestine satisfies these criteria. Firstly, though the territory of Palestine is not a continuous one, there is practice which indicates that the boundaries need not be fixed and that it can be the subject matter of dispute, and yet the entity may be recognized as a state. Secondly, though living in different territories, according to the Palestinian Central Bureau of Statistics, the estimated population on Palestinian territory in 2012 was a little over 4.2 million, thus satisfying the requirement of a permanent population. Thirdly, under Israel-PLO interim agreement on the West Bank and the Gaza Strip, some of the functions of government have been transferred to the Palestinian Authority, which it continues to perform in these territories. Numerous international organizations, including expert bodies of the UN, have attested to the capabilities of Palestinian Authority to govern and have endorsed its functioning and effectiveness. The Palestinian Authority exercises its capacity to enter into relations with other states. Despite the existence of these criteria, statehood in international law is closely connected to act of recognition. Recognition is essentially a unilateral and discretionary act, and its consequence is that the recognizing state cannot subsequently deny or act to the prejudice of the situation so established. The State of Palestine has been recognized as of November 2012 by 131 out of the 193 members of the UN, making its case for complete recognition of its statehood a stronger one. Another matter of importance here is the Palestinian people's right to self-determination. The international community has time and again reaffirmed the right of Palestinian people to self-determination. The fulfillment of this right can be achieved only if the establishment of a sovereign and independent state. The issue concerning the statehood of Palestine has once again gained international attention, with an overwhelming majority of the member states voting last year to upgrade the status of Palestine as a non-member observer state within the United Nations system. The issues highlighted in the special study and the work of ALCO on this issue is now of great significance, as the parties to the conflict have agreed to come for negotiation once again after a significant gap of time. Excellencies, ladies and gentlemen, with these introductory remarks, let me draw the framework for the deliberation which will follow. The deliberation focus on the violation of international law, particularly international human rights law and humanitarian law, committed by the government of Israel in the occupied Palestinian territory, or OPT, the role of the ICC in redressing this violation, and the role of the international community to pressurize Israel to comply with its international obligations. I thank you, Madam President.
Thank you. I'll open the floor for interventions. And the first speaker on the list is Honorable Minister of Justice for Palestine. You have the floor, sir.
بسم الله الرحمن الرحيم. شكرا سيدة الرئيسة. ابتداء اسمحوا لي أن أكرر الشكر والثناء على جهود منظمة أليكو في الشأن الفلسطيني، وعلى هذا الجهد الهام المتمثل في المنشورين الصادرين عن هذه المنظمة، سواء بشأن الحصار على غزة أو بشأن وضع دولة فلسطين في القانون الدولي. وإننا ننظر باهتمام بالغ وتقدير كبير لهذه الجهود التي لا تقدر بثمن. ونؤكد على أهمية هذا الكتاب المتعلق بمكانة فلسطين في القانون الدولي كمرجعية قانونية متخصصة، ليس على الصعيد الفلسطيني فقط وإنما على الصعيد الدولي أيضا. وتقديرا منا لهذا الدور ومساهمة منا في تعزيز وإبراز دور أليكو، فإننا سنسعى بعد عودتنا إلى الوطن لإصدار القرارات اللازمة لترجمة وإعادة طباعة هذا الكتاب ونشره إلى كافة المؤسسات والمنظمات والدول الصديقة في العالم. ولا يفوتنا في هذا المجال أن نتمنى على منظمة أليكو رئاسة وأمانة سر وأعضاء بأن يكون لفلسطين دائما وفي كل عام نصيب من منشوراتها على نحو متخصص، سواء كان ذلك بالنسبة لقضية اللاجئين أو الاستيطان والمياه والأسرى وغير ذلك. سيداتي سادتي، إننا ندرك بأن لقرار الجمعية العامة الصادر بتاريخ 29/11/2012 آثاره وتداعياته على الشأن الفلسطيني إيجاباً،